my life came full circle when I was able to walk into a courtroom as an assistant United States attorney and introduce myself to the court with great pride as Frank Amanat on behalf of the United States of America. One reason that they were comfortable being so brazen was because they assumed that these transactions were so complex, so arcane, that nobody would ever have the wherewithal to unravel the details of these schemes. But that's exactly what we did. Barack Obama was a classmate and friend of mine in law school. He said to my wife, "Frank is one of my favorite people in the world because he always gets the job done." So the through line is accountability. The through line is the diligent work that needs to be done to identify bad acts and bad actors and to build the evidence against them. Write everything down, memorialize everything. Memories fade, people forget things, evidence gets lost. You don't want to just rely on your memory, however good you think that memory is.
This is The Litigator's Edge, the podcast where smart strategy, practical innovation, and real-world experience come together to move litigation forward. Each week, we sit down with attorneys, legal tech leaders, and trusted advisors who are rethinking how great legal work gets done. You'll hear how law firms are building a competitive advantage. These conversations are grounded, insightful, and designed to help you refine how you work and how you win. Here is your host, Aniket Sawant.
Hello, and welcome to today's episode of The Litigator's Edge, the podcast where innovative attorneys reveal the strategies that have transformed their legal practice. My name is Aniket Sawant, and I'm co-founder and CEO of Threadio. My guest today is a litigator who has spent his career hunting down fraud and corruption at the highest levels, first on behalf of the government and now as a champion for whistleblowers and victims. He has led historic prosecutions that have resulted in settlements worth billions of dollars and now represents clients in high-stakes matters ranging from complex securities fraud to the fight for justice of victims of terrorism. On a separate and fascinating note, he is a former Jeopardy champion and a champion storyteller to boot. It's my privilege and pleasure to welcome Frank Amanat to the podcast. Welcome, Frank, and thank you for being here.
Thank you, Aniket, for having me on your show. I'm very excited to be here.
Likewise. Frank, as you know well, I love to start the show by asking each of my guests to share either a fun fact about themselves or a cringe joke. I know you have many of both. Which will it be for you and what is it?
Well, my family members will tell you that I'm famous for my cringe dad jokes, but I'm not going to share one of those today. I'll give you a fun fact, which is that some years ago, I wrote a children's book, a novel-length book for children, about a fictional republic made up entirely of frogs. And, there's a good story behind the genesis of that book, but that is the fun fact.
That's incredible. Maybe something for another episode. I would love to. My son, I know, would love to hear all about this story. So, thank you for sharing that, Frank. The other question that I love to ask, and I think is especially valid in your case, Frank, is I think of every attorney who makes the time to be on this podcast as a superhero, and every superhero has an origin story. Can you please share yours?
Well, that's very kind of you to suggest that I'm a superhero. I try to be a hero, at least, if not a super one. My origin story is that I basically grew up knowing that I wanted to be a lawyer. There's a number of things that contributed to that, but I think the most significant is that I grew up in the Baha'i faith, which is a religion that very much values justice and perceives it as our spiritual and moral imperative to devote our lives to procuring justice in the world around us, be it equality of men and women, racial unity, political unity. So I grew up with a value system that caused my worldview to be very much focused on identifying injustice and devoting myself to helping address it. And with that mindset, I found the intellectual enterprise of the practice of law just very stimulating as well. It seemed like a natural fit for me. And so I grew up in the St. Louis area, and after I graduated high school, I went to the University of Pennsylvania for college, where I majored in English and history. And then I went on to Harvard for law school and began my career. And I've been fortunate to have a very rewarding career as a lawyer. So
That's fascinating. Let's talk about a couple of formative moments that you had in your early childhood or mid childhood, and then maybe at Harvard Law School, because you were part of the Harvard Law Review, and there was a fairly well known individual who was also part of the Harvard Law Review. So we'll come to that in a second. But I had the opportunity, Frank, to look at one of your numerous stories that you've told at the Moth, and one of them spoke about the essentially the Iranian hostage crisis, and a key moment, and how that played out sort of at a personal level for you growing up, in St. Louis, Missouri, which is thousands of miles away from where all of this was happening. So can you maybe speak a little bit to that, and how that sort of fits into your origin story of justice, and what's right and wrong?
Sure. So my family immigrated to this country from Iran. My parents immigrated to this country from Iran in the early 1960s. So I was born in the United States. I was named after Franklin Roosevelt and grew up, like I said, in suburban St. Louis, Missouri, considering myself to be a regular, ordinary American. I loved baseball. There was nothing that caused me to question my Americanness until the hostages were taken in Iran. November of 1979. I was in seventh grade at the time. And, that incident in history prompted a great deal of turmoil. And it happened to have happened at a time, like I said, when I was in seventh grade. And seventh graders can be the cruelest people in the world. And as a result, I had to endure years of bullying and years of prejudice and directed towards me because of my Iranian background. And it was a very difficult time in my life, and a very lonely time. And it's the kind of scenario which could very well have prompted me to question my American identity and question my, and perhaps even gravitate more towards my Iranian ancestry. But it kind of had the opposite effect. If anything, notwithstanding what was going on around me, that set of experiences really caused me to recommit to my American identity. And intellectual enterprise in both college and law school was aimed at studying the question: what does it mean to be an American, and what does an American identity actually mean, as a way to kind of reconfirm that mindset. And it, to get back to your question in terms of my origin story as a lawyer, the combination of that experience and kind of my Baha'i upbringing and my Baha'i values and my commitment to justice really inspired me early in my career, that I wanted to give back to my community and help create and contribute to the justice in this country. And it's part of what drove me to the Department of Justice, where I spent 24 years in the bulk of my career.
That's amazing. Let's talk a little bit about your career at the Department of Justice. I remember from one of those videos that I saw that it was almost like a full circle moment for you. When earlier on here were all these individuals, young kids, obviously questioning your identity, and then on the other side you had the ultimate privilege of representing the United States. So can you maybe walk us at a high level through your career within the Department of Justice, and then we'll get into some of the details.
Yeah, so I started, what you're referring to was the statement I made in telling that particular story, that my life kind of came full circle when I was able to walk into a courtroom, in a federal courtroom in Brooklyn, as an assistant United States attorney, and introduce myself to the court with great pride as Frank Amanat on behalf of the United States of America. After having been kind of ostracized and told by my seventh grade and eighth grade peers that because of my skin color or my background, um, I didn't count as a real American. So it was an honor to go into court and represent the United States. So after I finished law school, I clerked for a judge in Washington, and then I spent 4 years as an associate at a big firm in DC, doing primarily commercial litigation and defense work. And I got a great early education as a lawyer and great training at that firm. But after a few years, I increasingly began to feel um, a bit frustrated that the cases I was working on involved representing big companies who were being sued by other big companies. And I knew that I wanted to work on cases that dealt with real people and issues of right and wrong. And I wanted to be able to get into court more and get some real hands-on experience in a way that you don't necessarily get as a junior associate at a big litigation firm. And so the obvious answer to me was the Justice Department. It was an opportunity for me to get into court, to have meaningful responsibility early in my career, while also working on cases that involved issues that really impacted our society. So I joined the Department of Justice in 1996, about 5 years out of law school. Initially, I was at Main Justice in Washington. And then I transferred to, after I moved to New York City, I transferred to the U.S. Attorney's Office in the Eastern District of New York, in Brooklyn, where I stayed for more than 2 decades. And, when I first started at the Department of Justice, I didn't know that I would end up staying there for 24 years. I figured I'd stay there for a few years, do the public service thing, get some experience, and then see where my career took me from there. But as it turned out, I just loved the job. Being an AUSA was the best job you could have as a civil litigator, representing federal agencies in both affirmative and defensive cases. And that office in Brooklyn is just an outstanding office with great prosecutors in both the criminal division and the civil division. And I ended up having a very rewarding, fulfilling career in the Department of Justice.
That's amazing. You've done a lot of remarkable work in the public service, but I would like to talk specifically about a landmark case that you led. You were the lead counsel for the government in the case against Barclays, which resulted in, I believe, a $2 billion settlement, which is the largest of its kind. Can you take us, me and our audience, into that investigation? What was it like to build a case of that magnitude against obviously a giant global financial institution, and what were some lessons learned for you and for society?
Sure. Just a little bit of background first. So, of course, many people remember the financial crisis of 2008, which wreaked havoc on the economy and just caused so much hardship to homeowners and people all over the country who suffered because of the impact of that financial crisis. And in the investigations that were conducted after the financial crisis, both in Congress and in the executive branch, to try to get to the bottom of what happened, it became clear early on that among the most responsible participants were the major financial institutions who had securitized home mortgages in these instruments called residential mortgage-backed securities, or RMBS. And they securitized millions of home mortgages in these exceptionally complex financial instruments that, unbeknownst to the public, were really designed to enrich these big financial institutions at the expense of ordinary people, to enrich Wall Street at the expense of Main Street. And so early in the Obama administration, the Justice Department developed a large working group to begin systematically investigating these financial institutions and other individuals and entities who were responsible for contributing to the financial crisis and for prosecuting them. And it was a large initiative that implicated attorneys in about a dozen U.S. attorneys' offices, as well as Main Justice and multiple partner agencies. And the early targets were the domestic banks like J.P. Morgan Chase and Citibank and Bank of America, most of which settled relatively quickly with the Department of Justice and reached large settlements. The foreign banks, however, were more resistant to settlement and required investigations and cases to be built. Even many of those ended up settling with the Department of Justice eventually without needing a lawsuit to be filed. Barclays, which I was responsible for leading the investigation, was the first bank that flat out refused to settle with the government, and that we actually had to bring a lawsuit and go into litigation against them. So in terms of building the case, one assessment that was made early on by this working group was that although there was a tremendous amount of public outcry and demand for criminal prosecutions of the individuals and companies that were responsible for contributing to the financial crisis, it was determined that bringing these cases criminally and winning them was going to be exceptionally difficult, if not impossible. These were extremely complicated financial instruments. The banks that had financially engineered these securities were very sophisticated in covering their tracks and in dispersing responsibility for the different pieces of the conduct amongst hundreds of people within the companies. So it was determined early on that being able to build evidence that could be proven beyond a reasonable doubt was likely unrealistic. So the department instead decided to use a little, to that point in time, little known statute called FIREA, the Financial Institutions Reform, Recovery, and Enforcement Act, which is a very interesting and powerful statute that allows the government to bring civil prosecutions against individuals or entities that commit fraud affecting financial institutions, and to use the tools of civil litigation and civil discovery to build a case, which ultimately they only have to prove by preponderance of the evidence, not beyond a reasonable doubt, without needing to go through grand juries, but having powerful tools built into the statute itself. So we had to build these investigations from scratch. There were a number of things that were very unusual about building this Barclays investigation. To that point in time, and this was about 2013 when my investigation of Barclays began, about 5 years after the financial crisis. And I'd been with the Department of Justice at that point for about 17 years. Virtually every one of the hundreds of cases I had litigated for the government to that point in time was staffed with teams of one, namely me. And it was highly unusual to have large teams of lawyers collaborate on a single investigation or a single prosecution. But that was necessary in cases like this. So I had to build from scratch what came to be a very large team of prosecutors, contract attorneys, investigators, data analysts, experts, investigative agents to work together basically exclusively on this case for a number of years. And it was a massive undertaking. We gathered terabytes worth of data. We deposed or interviewed dozens of potential witnesses across the country, tens of millions of pages of documents that we painstakingly had to craft to be able to unravel this fraud. And you have to keep in mind that at the end of the day, it turned out that banks like Barclays and the other banks that were held responsible for the financial crisis were actually quite brazen in their fraud and in the way that we had audio recordings of their phone calls where they were talking explicitly about ripping off the borrower at the end. One reason that they were comfortable being so brazen was because they assumed that these transactions were so complex, so arcane, that nobody would ever have the wherewithal to unravel the details of these schemes. Nobody would ever devote the resources to unravel their conduct and be able to hold them to account for it. But that's exactly what we did. We pieced together over the course of many years an exceptionally powerful body of evidence showing, unraveling the fraudulent scheme, showing exactly how they did it. And the other thing I'll tell you, which was unusual about the investigation, because I know it's a topic which is of particular interest to you, was our use of technology in this investigation. Artificial intelligence was at its very inception in 2013, 2014, and using artificial intelligence in litigation in particular. I could be mistaken, but I believe that the Department of Justice's investigations and prosecutions of the various financial institutions involved in the financial crisis and the RMBS crisis, including my Barclays investigation, was the first large-scale use of AI in civil litigation in the United States. The technology that we needed didn't really exist. So the Department of Justice had to engage contractors, technology companies to engineer custom made software and AI platforms for the Department of Justice to use to help it process all these data, these terabytes of data about millions of individual mortgages, these tens of millions of documents to systematically piece together how the fraud occurred, how they got away with it, how they covered it up. So we had to work very closely with our technology vendor to help us build this technology and use it and learn how to use it and train our team on how to use it. And for me, it was fascinating. It was the first time I had to deal with this. But you remember how I said that part of the way they got away, we thought they would get away with the fraud, was by dispersing responsibility across dozens of individuals in the company in multiple different locations within the company. So we had to use AI tools, and what's now common, but at the time was pioneers in relationship mapping to process tens of thousands of emails and phone calls and other communications and draw relationships, see who was connected to who was talking to whom. And so that's how we built this investigation. It was a lot of hard work. I had a very, very talented team of AUSAs, experts, investigators, contract attorneys that supported me. At the end of the day, they refused to settle before suing them. We filed a lawsuit against them in December of 16 in the waning days of the Obama administration. We then pursued that into litigation and just kept putting pressure on them, building a stronger and stronger case, winning motion after motion in court until eventually they cried uncle and they said, let's talk. And ultimately, we reached a settlement for $2 billion against the company and $2 million against two of the specific individuals who were most responsible. For the fraud, and I'm very proud of that achievement.
What a remarkable story, Frank. Thank you so much for sharing that. There's so many different threads to that, and I just want to touch upon a couple of them. Number one, as you were talking about, earlier on in this narrative about the common, not legal, but sort of the common societal perspective is, oh, nobody went to jail, etc. But then, thank you for laying out why the criminal approach would, may not have worked. And, if you wanted to get somewhere, the civil approach was sort of the way to go. And that's what you did. So thank you for sharing that. The other part of it that I thought was fascinating was how the perpetrators, as it were, felt that they could get away with it by hiding, by essentially abstracting away all the complex, all the transactions under multiple layers of complexity and delegation of powers and things like that. And the third part, which sort of speaks to that second part, is how you were able to use AI. And this is 13, 14 years even before it is the phenomenon that it is today in modern society. How you were able to unravel a lot of that and drive accountability for those individuals on behalf of the government through using those technologies. So that's a wonderful story. Thank you for sharing that, Frank.
Of course, and to your first point, even after the government ultimately, across all the banks who were investigated and ultimately held responsible, I think the Department of Justice's total recovery was, if I'm not mistaken, 65 or 70 billion dollars, which is an amazing, massive recovery. But of course, even after that, there were people who were disappointed, understandably, that the folks who were responsible didn't go to prison, didn't go to jail, that nobody went to prison. And look, I totally get that. I understand that where that sentiment is coming from in terms of viscerally people whose lives were ruined and whose life savings were totally decimated by this conduct, had a visceral desire to have people thrown in prison. And I shared that desire. But one has to understand just the realities and the complexities of bringing a case like this, which cost the government tens of millions of dollars to litigate these cases, to investigate these cases. It's a huge investment of resources, human resources, financial resources. And at the end of the day, I think the financial institutions were held appropriately accountable for their conduct. I don't know that they've necessarily changed their behavior because they continue to misbehave in other ways, which is a big focus of my current practice, but for their contributions to the financial crisis, I, for one, am satisfied that they were held appropriately accountable for their role in that.
Thank you for sharing that, Frank. And we'll come to your current practice in a little bit, but I want to take us back to your days in Harvard Law School. So you are one of those few attorneys who was a pioneer, not just in terms of the investigation and the use of technology there, but in the use of technology even back in law school. And there's a very interesting anecdote that I had the privilege of hearing in a separate video, and I would love for you to sort of share that with our audience in terms of how you leveraged your skills in technology in a very different area of law, and specifically with Harvard.
Sure. Yeah. So I was always an early adopter of technology. I always was fascinated by computers from an early age. And, I think I got my first personal computer back in 1980 when I was like 13 years old. It was one of those TRS 80s that Radio Shack would issue that had a whopping 16K of built in RAM memory. So I was always an early adopter of technology and always very fluent in technology. And this did come in handy when I was in law school. I had the privilege of serving on the Harvard Law Review, which is generally considered one of the most prestigious academic legal publications in the world. It's a student-run journal. I served on one of my classmates in law school was an individual known to your whole audience, I assume, unless they've been sleeping for the last 20 years. Barack Obama was a classmate and friend of mine in law school, and he, in the spring of 1990, was elected the first African American president of the Harvard Law Review, a very historic achievement on his part. And one of the things that he did was he tried to modernize the operations of the Law Review and introduce a whole new computer system. And because I was one of the more tech savvy editors on the board, he recruited me to essentially be the IT guy. We didn't hire an IT person. I was the one who played a significant role in helping to kind of roll out this new computer system and build it up and train folks on how to use it. I mean, in this day where everybody's got 15 computers in their pockets that they walk around with, but keep in mind in the early 90s, the internet was still new. Computer technology was at a much more basic stage than it is now. So the anecdote you're referring to happened in the fall of 1990. Barack Obama and I were in our third year at Harvard Law School, and the magazine came out every month, 8 times a year, every month. Not in the summer, but during the school year. It had systematically come out on the 10th of every month and had not had a late issue since World War II. And Barack had made it very clear he was not going to have a late issue on his watch. So in order to meet that deadline, we had to get the magazine, which that issue had basically been written, but we had to get the copy to our printer by a certain date. And in the lead up to that, one of the editors, I never figured out who it was, but it was apparently somebody who wasn't paying attention in my training classes, did something to mess up our entire computer system. The entire system crashed and the issue was lost. We couldn't find it. So Barack and everybody else was panicking. How are we going to retrieve this? So he called me at home. It was late one evening. I was getting ready to go to bed. He said, it's an emergency. You got to come in right now. Help us fix this. So it was freezing cold outside in Cambridge, but I traipsed over to the Law Review building. The whole masthead leadership was there. They were all very upset by what was going on. I said, I'll do my best. And again, I'm just a law student. I'm not an IT guy, but I said, okay, I'll do my best. And I ended up pulling an all-nighter and just, pulled out every trick in my book based on what knowledge I either knew or could figure out or experiment with. And it was a tough go, but about 7 o'clock or so in the morning, I finally managed to fix the crash, get the system back up. The issue was back on my screen. I was able to make a duplicate copy of it on floppy disk just in case. And Barack came in and he asked me how I was doing, and I said, "Yeah, I succeeded." He was very, very happy, and so he hopped on the kind of the building wide intercom, and he said, "Frank, you are the man. Hey, everybody, Frank is the man." So yeah, so it was great to be able to use my technology skills to help get the magazine on time. It came out that time, and I think it endeared me. I mean, we were already good friends and good buddies at that point in time, but I think, my willingness to get in there and problem solve and roll up my sleeves and do what it took to serve the organization, I think came in handy and kind of endeared me to him. So much so that many years later, when he was running for president of the United States, and I went to one of his campaign appearances with my wife, and he saw me in the back of the room, and at the end of the appearance, he motioned for me to come forward and gave me a big hug, and I introduced him to my wife, and he said to my wife, "Frank is one of my favorite people in the world because he always gets the job done." And so that made me feel good. It made me feel like maybe after all those years, I was still the man. So
That's great. Now, what a story, Frank. That's amazing. Um, Thinking now about maybe some more recent time in your career, right? And so, for the first 20, 25 years, as you mentioned, 24 years, you worked, on the government side, and then after that, more recently, you've made a significant pivot to the private sector, but not in the revolving door private sector kind of way that maybe that some other attorneys have, but more in terms of representing whistleblowers and victims, which to me, sort of is an interesting and very, very consistent through line, that goes from your belief in justice and so on and so forth, and that's fascinating. But what prompted that change to go from being part of the government to the private sector, and then to work specifically with whistleblowers and the other victims that you do?
great questions. Yeah. So look, after 24 years in the Department of Justice, I could look back and I had had an extremely rewarding career in government, and I was very proud of my accomplishments. But there came a time when I felt that I had done what I had set out to accomplish in the government. I had represented about 75 different client agencies over my time there. I had done every kind of work done in the office, and I wanted to branch out and do some new things. And I wanted to have, in particular, opportunities to be a little bit entrepreneurial, build a practice, build a business, be able to take some kinds of risks that you can't necessarily take as a government lawyer. And so I realized that as gratifying as my public service had been, it was time for me to explore opportunities in the private sector. At the same time, Aniket, my values hadn't changed. I still very much was about wanting to make a difference in the world, wanting to work on litigation that was intellectually stimulating, but that could have an impact on society. And so I gravitated towards plaintiffs' firms, which were a very natural fit for me. And I initially went to a different plaintiffs' firm after I left the Department of Justice in 2020. I was there a little over 3 years before coming here to Motley Rice about a year and a half ago. And in my time since leaving the department about 5 years ago, I have worked on a range of matters on behalf of plaintiffs and victims and whistleblowers. The bulk of my work has been in the False Claims Act space, representing whistleblowers who identify fraud and bring it to the attention. And that was a very natural fit for me because the False Claims Act creates a kind of public private partnership between private citizens who identify fraud and Department of Justice or state attorneys general who prosecute it. And we work closely with government partners to persuade them to take cases or to litigate cases alongside them. So that aspect of my practice was a very natural fit. And then the other work that I've done in the securities fraud space or in the antitrust space or on behalf of victims of terrorism or victims of trafficking and sexual abuse, those were opportunities that I was able to either hop onto opportunistically from work that my partners were doing, or I was able to develop organically through my own contacts. And it was also a very natural fit for my set of values and for the kind of lawyer I wanted to be.
That's fascinating. Thank you for sharing that, Frank. What would you say is sort of the through line between prosecuting, financial, claims of financial fraud and things like that, which obviously you've worked on for decades, and certainly more impactful, more visceral cases like terrorist attacks and sexual abuse and human rights abuse? What's sort of the common thread beyond obviously the values that you hold?
Well, the common thread is to hold bad actors to account. There's a lot of bad actors in this country, in this world, who are doing a lot of bad acts, and they get away with it in all manner of ways. At the end of the day, whether it's people who tell lies, who commit fraud, who steal money, who traffic women or children, who commit terrorist attacks. These are people whose value systems aren't properly calibrated and who are out to damage society, either for their own financial benefit or for their own ideological purposes. These bad acts inherently have victims, whether the victim be a federal government or a state government or an individual citizen, a trafficking victim, a competitor who's harmed by a non-competitive behavior, consumers who are harmed by deceptive practices. These victims, they need somebody to help them identify who the bad actor was, what the bad actor did, how they got away with it, how they covered it up, and what hold those bad actors to account. And they really can't do that without lawyers. I know lawyers like to toot their own horn, very often have an unjustified opinion of their own importance to society, but this is a space where lawyers really are necessary to help victims identify fraud or other bad acts and help bring some compensation to the victims. So the through line is accountability. The through line is the diligent work that needs to be done to identify bad acts and bad actors and to build the evidence against them. The through line is to do the diligence to find assets that you can reach for these defendants so that you can not only hold them accountable, but provide a measure of compensation to the victims. So that's how I would answer your question.
Thank you, Frank. Thinking going back to whistleblowers, right? And so for those of us sort of not as directly involved with matters involving whistleblowers as you obviously are, a whistleblower can seem like an abstraction. Here's a person who saw something wrong, raised their hand, and then and then went out and shared whatever information they had. But better than sort of anybody who's listening, more or less, that it's a lot more than that. So from your perspective, what would you say is the anatomy of a whistleblower? What drives them? What are some of their biggest fears? It's not I would imagine it's not a decision that they take lightly. And so, how do you work with them, and how do you guide them through what I would imagine is an incredibly stressful journey for them?
That's an excellent question, Aniket. It certainly can be an incredibly stressful journey. I wouldn't say there's a single anatomy to whistleblowers. They come in many different permutations. But I think one commonality is that these are all individuals for whom the phrase, if you see something, say something, resonates. And their motivation ultimately is in line with what I was saying earlier, accountability. These are people who can't stand to see bad actors get away with their bad actions and either defraud the government or defraud investors, defraud consumers. Whistleblowers can come in all different kinds of permutations. Many of them are insiders of the companies or entities that they're blowing the whistle on. Those are obviously the individuals who are best situated to have information about what's happening. But whistleblowers can also be competitors, whistleblowers can be customers, whistleblowers can be contractors or other witnesses who engage in transactions. And witnesses can also be people totally unrelated to the bad actor who discover the fraud through data analysis and just being home detectives and piecing together information that they see and using their intuition and their experience or their expertise in a particular area to identify pattern of fraud. And their biggest fear is blowback. Whistleblowers can and often do face retaliation. They face people who don't want to believe them, who don't accept their story, who take active measures to persecute them or to fire them, terminate them. And the fear of that can be exceptionally stressful for a whistleblower. And it really takes courage for them to come forward. And I have so much respect for my clients, my whistleblower clients, who most of whom are motivated by genuinely altruistic desires to bring about a better world and to hold bad actors to account. And it takes courage, it takes perseverance. And so as their lawyer, I of course have to give them legal advice, guide them through the steps of what's a very complicated and sometimes arcane and lengthy process that can be very frustrating to them, while also encouraging them and continue to try to help them not lose hope that someday they may achieve the accountability they seek.
That's amazing. Yeah, it's so much. It's so driven by the values of the whistleblower and the accountability to your point that they want to see in the world and the part that they can play and the part that you can play in supporting them in getting to that accountability. So thank you for sharing
Right.
that.
Of course.
Talking about technology, obviously we spoke about your remarkably effective use of technology back in 2013 with the whole Barclays saga, and then obviously many years back in Harvard Law. Where do you see technology today, and what are its applications in terms of enabling you to do the work that you do? So two-part question: enabling you to do the work that you do in terms of combating fraud, in terms of targeting those bad actors, but also in terms of what the bad actors themselves are using technology for. And so what's your lay of the land in terms of how technology is being used today?
The technology gets more sophisticated by the day. And you're absolutely right that the bad guys, as we like to call them, they definitely are using technology increasingly to not only to commit fraud or other bad actions, but also to hide it, to conceal it. And so, as a lawyer who works on these cases and is trying to discover fraud, investigate fraud, build a case against these bad actors, we have to stay a step ahead of them. We have to stay abreast of the technology. In the spaces in which I work on, I think you see technology being used in many different ways. I am not one who has, to this point in time at least, embraced the use of generative AI for things like drafting legal documents, complaints, briefs, and so forth and so on. I tend to do that myself. But I think in many of these cases, which are massive document or data cases where we have terabytes of data, millions of documents, the only way you can efficiently process that information, um, digest it, and be able to make use of it in litigation is to use technology, predictive coding type technologies, and other technologies that help efficiently review large quantities of data to build your case. Do that relationship mapping that I described earlier from the Barclays case, and help build dossiers and on individual witnesses and individuals who you want to talk to. Um, so I think, well, taking a step back, I think we're increasingly using technology to identify fraud in the first place through data analysis and studying patterns of conduct in the financial space. Lawyers are doing that, whistleblowers are doing that. I think, for example, if I have a client, one of the big cases that I'm working on involves another lawsuit against banks. In this case, they're alleged to have colluded with one another to manipulate and inflate the interest rates that they set on a particular type of municipal bond in a way that profited themselves and was to the detriment of cities and counties and towns in multiple states across the country. And my client, who was a municipal finance expert, he initially discovered the fraud through technology. I mean, he had identified some anecdotal patterns in these interest rates which didn't make any economic sense. And so he put together a team that engineered software that could crunch the numbers and study this problem on a massive scale. And he saw when he did that, that there were significant patterns of fraud, that significant patterns with regard to the interest rates on these bonds that could only be explained through collusion and fraud. And that was the genesis of our case. which we've been litigating for a number of years and is now heading towards trial. So our clients are using technology to help unravel the fraud. We as lawyers have to do that. And then in cases like, cases against on behalf of victims of terrorist attacks or cartel attacks, technology comes into play in asset location and finding the assets and following the money, so to speak, to find out where the money is that we can go after to be able to bring some level of accountability and compensation to our clients.
Amazing. What really struck me from that narrative there, Frank, was the fact that you mentioned that the client had actually done all this work with the advanced technology and identified the patterns, which I'm sure helps set the foundation for a stronger case, obviously, with you and your team and your expertise
Right.
to come in and build on that, which is incredible. Frank, this has been an incredible conversation. Just a few questions to wrap this up as we come to the top of the hour. So one is, given your experience both on the DOJ side, representing the government, and then on the private sector side, representing whistleblowers and others who are seeking accountability, what advice would you give to a younger, maybe earlier career attorney who's trying to decide which way to go? And what are maybe some of the unique pros and cons or unique rewards that each path brings that someone in that position should do well to keep in mind?
So I don't necessarily see a career in public service and a career in the private sector as being mutually exclusive. And I think, as my pattern indicates, which is not unique, there are many people who start in the private sector, go into the government, and return to the private sector, or some other permutation of that. So I would recommend to a young attorney who is trying to make that decision to perhaps start in a law firm, get their feet wet. You'll work hard, but you'll get some excellent training and you'll learn the ropes. And then consider a transition to some form of public service, whether it be in the Justice Department or a federal agency or a state attorney general's office, and see how it goes. Maybe you'll fall in love with it as I did it and end up spending 2 decades there. Maybe you'll be ready to move back to the private sector after a few years. Either way, you will have contributed to your community, and you will have learned a lot. In terms of the pros and cons, I think my advice would be, whatever situation a young lawyer finds himself in, whether it be at a private firm or in the government, make the most of the experience. Look at your experience as being like being in a learning hospital. Ask questions. Be curious. Try to learn as much about the firm's practice, the agency's practice, the government's practice as you possibly can. Make connections. Start building your network early on, whether you're in the private sector or in the government, because it will come in handy down the road.
That's great. Now, switching to advice for someone who's maybe sitting inside a company and witnessing what they believe might be malfeasance or fraud of some nature, what would your single most important piece of advice for that prospective whistleblower be? What is the first step they should take? What should they be thinking about?
Write everything down. Memorialize everything. Memories fade. People forget things. Evidence gets lost. It's really important that whatever you observe, you write it down. You write down facts, dates, names of people, as much detail as you possibly can. Memos to self, and document it in some fashion. Keep a journal, because at the end of the day, if you decide to go forward and be a whistleblower and have meetings with people like me, we're going to want to know the details, and we're going to have to provide those details at some point to the government and maybe eventually to a defendant. And you don't want to just rely on your memory, however good you think that memory is. So write everything down.
Amazing. One, there's so many aspects to your professional career and also to your sort of non-professional interests. I do want to touch upon one of those non-professional interests before we sign off here, and that is your role as a Jeopardy champion, and specifically the intersection between your time on the show and sort of using your legal training. So maybe in just a minute or two, can you share that anecdote, which was hilarious to me?
I will give you the short version. Yes, I've always been a trivia buff. Ever since I was young, I started accumulating a large amount of fairly useless information in my head, which My friends at some point labeled the Frank file as the repository of this information. And about 2 decades ago, in 2003, I was fortunate enough to be able to use that that Frank file and the my being a trivia buff to become a contestant on Jeopardy. And I appeared on the show in 5 discontinuous episodes, and that's what makes the story a little bit interesting, because I was initially on an episode in November of 2003, which had a very controversial ending. I don't have time to get into the details of it. People can watch my YouTube video where I tell the whole story if they are interested in seeing it. But the long and the short of it is that going into Final Jeopardy, I was in the lead. I received the Final Jeopardy clue was a very awkwardly worded and ambiguous clue that was also of dubious historical accuracy, but I provided a correct response. And yet Alex Trebek, I think himself, misunderstood the clue. And so he ruled my response incorrect, and I ended up losing. And I wasn't, but they move you off the stage right away to get ready for the taping of the next episode. And so I wasn't able to speak up for myself or do anything about it. But I came back to New York, and I then did what any self-respecting lawyer would do. I filed an appeal, and I brought to bear all of my Harvard Law School training in drafting and crafting a very detailed appeal, which cited precedent and statutory interpretation and everything I could think of. And a few weeks later, I got a call from their contestant coordinator who told me that the producers had considered my appeal and had decided to grant it. And she went on to say that she'd been with the show for something like 20 seasons, and each year they get 5 or 6 appeals from losing contestants, and that she'd never seen, none of them had ever seen an appeal that was anything like mine, which of course made me feel good. And I felt like I'd won a case at the Supreme Court. So I was invited back onto the show for a second gig. And on that second go round, I won 3 games, lost my 4th game fair and square. I made about $60,000 and came away with a pretty good story to tell.
Absolutely. Thank you for sharing that, Frank. That was incredible for me to hear, in the video, which I will share in the show notes, as well as from you right now. So, Frank, I know we could go on for easily, an hour more or even longer, but final question for you. Is there a question that I should have asked you, but I didn't?
I think you covered the ground, man. I think it's been a tremendously rewarding conversation. I really appreciate your inviting me onto your program. Really enjoyed the conversation. So thank you very much. And I hope your audience enjoyed it as well.
Absolutely. Thank you, Frank. Again, it's been a pleasure. It's been a fulfilling, enriching, enlightening conversation for me. I certainly learned a lot, and I'm sure our audience will as well. So thank you very much.
Thank you very much.
The Litigator's Edge podcast requires more than a conversation. It takes action, research, and collective wisdom. If today's episode resonated with you, we'd love to hear your insights. Join the conversation and help us shape the future together. We'll be back with more stories, strategies, and real-world solutions that are making a difference for everyone. In the meantime, be sure to subscribe, rate, write a review, and share it with someone you think would benefit from it too. Thanks for listening, and we'll see you on the next episode.